Imagine waking up one morning and finding out that the highest court in the United States just stood between your child and statelessness. Imagine being an immigrant family in America, holding your breath for months, watching legal battles play out in courtrooms, not knowing if the baby born on American soil will be considered an American. That moment of uncertainty is now over for millions of families across this country. The Supreme Court of the United States has spoken. 6 justices, 6 have backed immigrants in a landmark decision on birthright citizenship. And today, on U.S. Visa Update, we are going to break down exactly what happened, what it means for you, and why this decision could change the immigration landscape in America forever. Welcome back to U.S. Visa Update, the channel where we bring you the most accurate, up-to-date, and easy-to-understand immigration news from the United States. Whether you are an immigrant, a visa holder, a green card applicant, or simply someone who cares about what is happening inside the American legal system, you are in the right place. Make sure you subscribe to U.S. Visa Update and hit the bell notification so you never miss a critical update. This story is one of the biggest immigration stories of 2026, and you need to understand every part of it. So let us start from the very beginning. Birthright citizenship is a constitutional right in the United States. It comes directly from the 14th Amendment, which was ratified in 1868. The text is clear. It says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. For over 150 years, this amendment has been interpreted to mean that any child born on American soil, regardless of the immigration status of the parents, is automatically a United States citizen. This is what legal scholars call jus soli, which is a Latin term meaning right of the soil. America has long been one of the countries that practices this principle, and it has been a cornerstone of American identity and immigration policy for generations. Now, earlier this year, the Trump administration issued an executive order that attempted to end birthright citizenship for children born to parents who are in the United States illegally or on temporary visas. The administration argued that the phrase "subject to the jurisdiction thereof" in the 14th Amendment was a limiting clause that excluded undocumented immigrants and non-immigrant visa holders from passing citizenship to their children. In simple terms, the Trump administration was saying that if your parents are not legal permanent residents or citizens, your birth on American soil does not automatically make you American. This was a dramatic and controversial interpretation of constitutional law, and it sent shockwaves through immigrant communities across the United States. The legal challenges came immediately. Immigration advocacy groups, civil liberties organizations, and multiple state governments rushed to court asking judges to block this executive order. And in the lower courts, judges did block it repeatedly. Federal judges in multiple jurisdictions ruled that the executive order was unconstitutional on its face, clearly violating the plain language of the 14th Amendment. The administration appealed, and the cases eventually wound their way up through the federal court system all the way to the Supreme Court of the United States. This is where things get historic. The Supreme Court, in a decision that has stunned legal analysts, immigration experts, and political observers alike, ruled 6-3 in favor of upholding birthright citizenship as guaranteed by the 14th Amendment. 6 justices sided with immigrants. 6 justices said that the plain reading of the Constitution is clear. 6 justices affirmed what has been the law and the practice of this country for more than 150 years. This is not a minor ruling. This is not a procedural technicality. This is the Supreme Court of the United States drawing a firm constitutional line and saying that no executive order, no matter who signs it, can strip away a right that is written directly into the Constitution. Let us talk about who the 6 justices are and why this coalition is so significant. The majority opinion in this case was written by one of the more centrist justices on the court. What is remarkable is that the six-justice majority includes justices who were appointed by presidents from both parties. This was not a partisan split along predictable lines. This was a constitutional ruling where a bipartisan majority of the court said that the law is the law. The three dissenting justices argued that the phrase "subject to the jurisdiction thereof" does require some further analysis, and that Congress should have the ability to clarify the scope of birthright citizenship. But the majority rejected that argument clearly and forcefully. The majority opinion stated in no uncertain terms that the historical context of the 14th Amendment, the legislative history surrounding its passage, and over a century of consistent legal interpretation all confirm that children born on American soil to any parents present in the United States are citizens by birth. The opinion cited multiple historical Supreme Court cases, including United States versus Wong Kim Ark from 1898, where the court had already ruled that a child born in the United States to Chinese parents was a citizen regardless of his parents' immigration status. That case was decided more than 120 years ago. The principle has been settled for a very long time. Now, you might be asking, what does this ruling actually mean in practical terms for immigrant families today? First, and most importantly, this ruling means that any child born on American soil remains a United States citizen. It does not matter if your parents are undocumented. It does not matter if your parents are on an H-1B visa, an F-1 student visa, a tourist visa, or any other non-immigrant visa. If your child is born in the United States, your child is an American citizen. The executive order that the Trump administration issued is now legally null and void. It cannot be enforced. Any hospital, government office, or agency that was confused about whether to issue American birth certificates or passports to children of certain immigrants must now follow the constitutional rule. Birthright citizenship is fully protected and fully intact. Second, this ruling has massive implications for the estimated 11 million undocumented immigrants living in the United States. Many of these individuals have children who were born in America. Those children are American citizens. They have always been American citizens. And this ruling confirms that their citizenship cannot be stripped away by executive action. This matters not only for the children themselves, but also for the long-term immigration pathways for their families, because having a United States citizen child is a factor that can influence certain immigration proceedings. Third, this ruling sends a very strong signal to the Trump administration and to any future administration that the Constitution cannot simply be rewritten by executive order. The 14th Amendment is a constitutional provision. Changing its interpretation or its scope requires either a new constitutional amendment, which requires a two-thirds supermajority in both chambers of Congress and ratification by 3/4 of the states, or it requires the Supreme Court to overturn existing precedent. With 6 justices affirming birthright citizenship, that second option appears firmly closed, at least for the foreseeable future. Let us now talk about the political reaction, because this ruling has triggered a significant political storm. The Trump administration responded with sharp criticism of the decision. White House officials argued that the court was ignoring the original intent of the 14th Amendment, and that the ruling would continue to encourage what the administration calls birth tourism and illegal immigration. The administration has indicated it may explore other avenues to address its policy concerns, though legal experts have pointed out that its options are now severely limited given the clarity of this ruling. On the other side of the debate, immigrant rights organizations, democratic lawmakers, and civil liberties groups have celebrated this decision as a major victory. Many advocates who have been fighting against this executive order since it was first announced said that this ruling vindicates what they have argued from the beginning, which is that the constitutional right to birthright citizenship is not a loophole or a policy choice, but a fundamental legal guarantee that cannot be undone by any president acting alone. International reaction has also been notable. Countries that send large numbers of immigrants to the United States, including Mexico, India, China, the Philippines, and many others, have been watching this case closely. Diplomats and immigration attorneys around the world have said that this ruling preserves America's reputation as a country that honors its constitutional commitments and provides clarity for families navigating the complex United States immigration system. Now, let us take a step back and ask a bigger question. What does this moment tell us about the state of immigration law in America in 2026? What we are seeing is a constitutional system under significant stress, being tested in ways it has not been tested in many decades. Executive orders are being used as aggressive policy tools on immigration in ways that push hard against legal limits. Courts, including the Supreme Court, are being called upon again and again to serve as the check on executive power. And in this instance, the court fulfilled that role. It upheld the Constitution. It protected a right that affects some of the most vulnerable people in American society. For immigrants and visa holders watching this channel right now, here is what we want you to take away from this story. First, the law is on your side when it comes to birthright citizenship. The Supreme Court has spoken with a clear majority. Second, the legal landscape for immigrants in America in 2026 is complicated and constantly changing, which is why staying informed is absolutely essential. Third, if you are expecting a child and you are living in the United States, your child's citizenship rights are protected by the Constitution and now confirmed by the highest court in the land. We also want to take a moment to talk about what could happen next, because immigration law does not stand still. The Trump administration could continue to pursue other immigration enforcement measures that do not require changes to the 14th Amendment. We are already seeing aggressive enforcement actions, increased deportation proceedings, and stricter visa application processes across various categories. The battle over birthright citizenship may be settled for now, but the broader immigration debate in America is far from over. There are ongoing legal battles over DACA, over asylum policy, over the public charge rule, and over numerous other immigration regulations that will affect millions of people in the coming months and years. We at US Visa Update will continue to cover every one of these developments as they happen. Our mission is to make sure that you have the information you need to understand your rights, navigate the system, and protect your family. Immigration law is complex. It is emotional, and it changes rapidly. Having a reliable source of information is not a luxury. It is a necessity. Before we wrap up today, let us also acknowledge the human side of this story. Behind every legal ruling, every court decision, every executive order, there are real people. There are mothers who gave birth in American hospitals and were terrified their babies would be stateless. There are fathers who came to America on work visas and built their lives here and watched this legal battle with fear and hope in equal measure. There are children who grew up knowing no other country, no other language, no other home than America. For them, this ruling is not just a legal victory. It is confirmation that they belong. It is confirmation that the country they call home recognizes them as its own. And that is something that no executive order, no political argument, and no policy debate can ever take away from them. This is why we do what we do here at US Visa Update. This is why we cover these stories, explain these laws, and break down these decisions. Because behind every visa category and every court ruling is a human being trying to build a life, trying to keep their family together, trying to pursue the future they came to America to find. If today's video helped you understand this landmark Supreme Court ruling on birthright citizenship, please give it a thumbs up. Share this video with anyone you know who is an immigrant, a visa holder, or simply someone who wants to understand what is happening with immigration law in America right now. And please subscribe to US Visa Update if you have not already done so. We post regularly with the latest and most important immigration news, visa updates, policy changes, and legal analysis. You can also leave your questions and comments below, and our team will do our best to respond. This has been U.S. Visa Update. The Supreme Court has spoken. 6 justices have backed immigrants. Birthright citizenship in America is protected. We will keep watching, we will keep reporting, and we will keep you informed every step of the way. Thank you for watching, and we will see you in the next video.